Okay, good morning, everybody. Thanks for attending the webinar information session on the Short-Term Rental Accommodations Act. First, I want to take a moment to recognize that I'm joining you today from the traditional unceded territories of the Lekwungen-speaking peoples, today known as the Esquimalt and Songhees Nations. And I'd encourage you to each take a moment to think about the land that you are joining this call from. My name is Jade Ashbourne. I'm the Executive Director in the Housing Policy Branch, and I'll be facilitating the session today. We have Hannah Rabinovich with us today, who's a director in our branch. She'll be joining me answering questions at the end of the presentation. We've also got Erica Greenup and Catherine Levitt from the Ministry of Housing here. They're going to help with reading out your questions and assisting with any tech concerns. There are a lot of you on the call. We've got 135 people who have joined so far, and we're expecting more. I believe we had somewhere around 200 signed up for this. So to make the best use of your time, we've opted to do this in a webinar format. What that means is, just for your awareness, the webinar is being recorded for future use. It will be available to folks who are needing this information down the road. As well, just like the other webinars we've done, the participant chat, the cameras and microphones are disabled for the duration of the webinar. A Q&A chat function is going to open near the end of the presentation for you to ask questions. You can enter new questions. You can also upvote other questions that you like so that they rise to the top of the list. Erica will read out your top questions for us to respond to, and we'll do our best to answer your questions at that time. I'll remind you about some of these features when we launch that. If you have follow-up questions after the session, we've also just posted the branch email in the chat. That's right there, housing.policy@gov.bc.ca, and you can use that to follow up directly with us. In terms of what we'll cover today, we'll go to slide 2, please. Today, we're going to cover the short-term rental situation in BC, why action is needed. We're going to give a bit of an overview of the provincial short-term rental legislation, provide some key considerations for local governments, in particular, focusing on things like business licensing, local government bylaws, and the provincial PR requirement, non-conforming use properties, opting in and out of the provincial PR requirement, and the expected impacts of the legislation. We're also going to cover a bit of information on the timeline for this, and then provide the majority of the time today for questions. If we go to slide 3, please. The current situation for short-term rentals in BC. Finding an affordable place to live is already a big challenge, and we know that short-term rentals are making the problem even worse. Online hosts for short-term rentals through platforms such as, for example, Airbnb, VRBO, Expedia, or Flipkey have rapidly expanded, surging post-pandemic. Currently, there's about 28,000 STR listings in BC. That's an increase of 20% from 2022. And research from McGill University indicates that more than 16,000 entire homes in BC are being frequently used as STRs, impacting the housing market for those looking for long-term housing. There's a number of studies and websites that are dedicated to STR research, and they provide us some information like the fact that the STR market in BC is dominated by a small segment of profit-driven operators, mini hotel operators. The top 10% of hosts actually earn 48.8% of all of the revenue, and nearly half of the operators have multiple listings. So in that context, government brought in the Short-Term Rental Accommodations Act last fall. It aims to turn short-term rentals back into homes for people through 3 key responses. First is strengthening local government's tools to enforce their short-term rental bylaws. This includes increasing maximum MTI fines for operators breaking local rules, requiring STR platforms to share data to improve local enforcement, increasing STR platform accountability, providing regional districts with more tools and support. It also includes returning short-term rental units to the long-term rental market. This means limiting short-term rentals in BC to principal residences only, plus 1 additional unit on that property for larger BC municipalities and adjacent communities. Or removing legal non-conforming use protections for short-term rentals. The third key response is around establishing provincial oversight of short-term rentals. This will include requiring all STR hosts to join a provincial registry and establishing a provincial short-term rental compliance and enforcement unit to make sure that the rules are being followed. The next slides are going to provide an overview of each component of the legislation for you, starting with strengthened tools for local governments. The first thing I want to talk about is that maximum fines have been increased. And it's important to note that this change is applicable beyond short-term rental bylaws. The maximum fine that regional districts can set for prosecutions of bylaw offenses under the Offence Act has increased from $2,000 to $50,000. This is consistent with the maximum fines for municipalities under the Community Charter. The maximum municipal ticketing fine that a local government can set under the Community Charter Bylaw Enforcement Ticket Regulation and the Vancouver Charter Bylaw Enforcement Ticket Regulation has increased from $1,000 to $3,000 per infraction per day. I just want to note, I know we've had some questions, and the Ministry of Attorney General administers the Bylaw Notice Adjudication Program and is responsible for the Local Government Bylaw Notice Enforcement Act. The Attorney General Ministry is not making changes to the fine amount of $500 at this time on that part. I also want to note that through the changes in the fall, regional districts have new business licensing authority. They can now regulate and license STRs and other businesses, just like municipalities can. Finally, business licenses are also now required on short-term rental listings. Effective May 1st of this year, short-term rental hosts must display a valid business license number on their listing in areas where a business license is required by the local government. In addition, to further support local governments' efforts to enforce their short-term rental bylaws, we are launching a new data sharing system. In summer 2024, a new data sharing system is going to launch that will require platforms to submit their data to the province. They'll directly provide that STR listing data to the system, and that will then be distributed to local governments. In the coming months, we'll be signing data sharing agreements with local governments before the system launches. Can also let you know that data sharing is expected to include information such as names and addresses and booking information. And just to be aware that local governments will only receive listing data for their own jurisdiction. Around platform accountability, we know that there have been concerns raised in past about this. And so under the Act, platforms must remove listings without a valid local government business license upon request. Further information on how the data sharing system will work and the platform accountability process are going to be provided in a further set of regulations that will come this spring, and we'll provide more information at that time as well. The next sort of key stream of work is around returning short-term rental units to the long-term rental market. This slide covers that part of the legislation, including changes to legal non-conforming use protections. So as of May 1st, 2024, protections for non-conforming use of property will no longer apply to short-term rentals. We know that in some areas, these protections have allowed STR hosts to keep using their property for short-term rentals, even when local government rules wouldn't allow it. We also have made changes to bring in a provincial principal residence requirement. So as of May 1st again this year, in communities where the requirement applies, short-term rentals will be limited to the host's principal residence, plus either one secondary suite or one ADU on the property. We're going to provide some key considerations around these parts of the legislation for local governments later in the presentation as well. So these are the areas where the provincial PR requirement applies and where it's exempt. For a detailed list, you can also view our website, which will pop in the chat here. So in general, the PR requirement applies to municipalities with 10,000 people or more and to smaller neighboring communities, adjacent communities next to those larger ones. In general, it's exempt, however, for mountain resorts, the 14 resort municipalities, regional district electoral areas, and small communities under 10,000, with the exception of those neighboring communities mentioned above. Trust areas under the Islands Trust Act and farmland, that's BC Assessment Farm Class 9, are also exempt. While the provincial PR requirement will be enforced at the provincial level, local governments also shouldn't grant zoning or other permission to short-term rental hosts where it's inconsistent with the provincial legislation. I want to be clear, it doesn't mean that local governments are required to validate that hosts are in compliance with the law, but it would be a good idea to be clear with applicants for licenses where they need to be in line with the PR requirement, for example, in order to apply for a license. The next two slides cover the final stream, the areas of provincial oversight that are going to come into force over the coming year. First of all, when it comes to the provincial registry, in late 2024, early 25, the province will establish a short-term rental registry. Registration is going to be mandatory for both hosts and platforms. And this registry will help ensure that all hosts and platforms are following the rules. Once it's in place, hosts will have to display their provincial registration number on their listings, and platforms will be required to validate those numbers when people are posting listings against the province's registry data. It's also important to note where a certain area or an accommodation type might be exempt from the principal residence requirement. In many cases, the host will still be subject to other components of the Act, such as the requirement to register with the province. The exception to that is for hotels and motels, which are exempt from the entire Act. When we look further into the provincial oversight tools, the Provincial Compliance and Enforcement Unit will be established this year. This will ensure that rules are being followed by both hosts and platforms. It will track compliance, issue orders, and administer penalties for violations. Future regulations will provide added support for local government regulation. Important to be clear here, local governments will continue to enforce your own bylaws, while the Provincial Compliance Unit will be responsible for enforcing the Provincial Short-Term Rental Accommodations Act. So it will complement local government bylaw enforcement and will also become the key provincial contact for local governments on short-term rental regulation. There will be a designated local government contact within the Compliance and Enforcement Unit, and that individual and contact information will be shared as soon as it's available. We're now going to go over some key considerations for local governments related to this legislation, starting with local government business licenses. After May 1st, as I mentioned, municipalities regulating STRs may consider reviewing and updating business license bylaws to align with the STRAA, Short-Term Rental Accommodations Act. They may want to inform hosts early. You may want to inform hosts early about their ability to operate post May 1st. And local governments may want to consider prorating business licensing for non-principal residence STRs from January to April 30th, recognizing that they won't be able to continue to operate after that point. Also important to note that the Short-Term Rental Act supports local governments to maintain their own definitions of short-term rentals, even where these are distinct from the province's 90-day definition for local bylaw purposes. This means that if you have local business bylaws that only apply to rentals under 28 days, they're still valid, they're still able to operate, they will only apply to those under 28-day ones, where the province's rules will apply to all rentals for less than 90 days. The province's principal residence requirement functions as a minimum requirement or a floor, but there are some other bylaw restrictions that local governments may wish to consider. Some local governments have more restrictive STR bylaws depending on their local needs. You might want to consider some of these additional requirements, which are used by other local governments that are currently regulating STRs. For example, some regulate types of units that can be used for short-term rental, for example, whether to prohibit in secondary suites or ADUs. Some set a maximum density of short-term rentals or a percentage of total dwellings in a community that can be used for STRs. Some set a maximum number of nights a short-term rental unit may be rented per year, a maximum number of guests per unit, road network or parking requirements, zoning requirements, local host and contact requirements, or fire or safety standards. When we look to non-conforming use properties, there's some key considerations here for local governments. First of all, with the end of non-conforming use protections for short-term rentals on May 1st, local governments may wish to assess the local impacts of ending this legal non-conforming use for STRs, including any bylaw or operational considerations. You'll also want to decide if short-term rentals that conform with provincial rules, such as the principal residence requirement, but which were reliant on non-conforming use protections, should be allowed to continue operating. If so, this may require updates to local zoning bylaws. And I want to flag that this might be particularly relevant for resort municipalities where we know the principal residence requirement doesn't apply. We've also received a number of questions on opting in or opting out of the principal residence requirement. These details are set out in further detail as well on our website. So again, that has been posted in the chat, and I'll encourage people to follow up there if there are further details you're looking at for this process. But at a high level, communities can request to opt in by resolution to the province's principal residence requirement. These requests will be due by March 31st. There's an opportunity to apply each year, with changes received by that March 31st taking effect on November 1st of the same year. Some exempt areas, like designated ski resorts or mountain resorts or farmlands, can't be changed by local requests. Also important to note when it comes to the Islands Trust or Cultus Lake Park, they can independently request changes in their areas rather than the municipalities or regional districts in those areas requesting for them. When it comes to the opting out process, similarly, communities can request to opt out of the province's provincial residence requirement. The requirement to do so, though, is that the rental vacancy rate has to be 3% or more for 2 consecutive years. For 2024, the request deadline is February 29th. That's earlier than usual. And it will take effect this year when the new rules come in May 1st. This provides an opportunity for those communities that qualify to opt out and wish to do so to opt out before the requirement comes into effect so that it will never take effect in their community. From 2025 onward, the requests to opt out are going to line up with the requests to opt in. They'll be due by March 31st each year, with changes taking effect on November 1st again. Also important to note that treaty nations can approach the ministry to establish a coordination agreement under the legislation at any time. It's expected that local governments will need to pass a resolution to decide to opt into the PR requirement by the set date above, giving hosts notice to comply with the requirement. The province would then pass a regulation updating in law where the PR requirement applies starting later that year. The goal of this legislation is to return thousands of housing units to the long-term market and to stem the loss of existing housing to the short-term rental market, which we've heard anecdotally is already starting to occur. It's also our goal to allow people to find long-term housing in their home communities and where they work or study. To improve local government's ability to regulate STRs in your communities, and through it all to ensure that tourism-dependent communities have the flexibility they need to continue to support the important tourism sector of this province. Before we go through the last few pieces of information here, I just want to let you know that we'll now be opening the Q&A chat function for you to ask questions. Just a refresher, or for those who joined after the beginning, you can enter new questions, or you can upvote other questions that have already been entered so they rise to the top of the list. Erica will read your top questions for us to respond to, and we'll do our best with the time we have to answer as many questions as possible as they come in. We will also post our contact email again in the chat where you can send any follow-up questions after this session. Before we go to questions, though, a little bit more detail here on timelines. So if you look at the slide in front of you, the supports for municipalities and local governments took effect right away last fall. We provided some notice for hosts, and the PR requirements, non-conforming use changes, and business license requirements will come into effect on May 1st, 2024. Starting May 1st, platforms will also be required to enable the display of business license numbers across the province, and hosts will be required to post a valid business license number where that's required. This summer, data sharing will begin with platforms, which will also begin platform requests to remove listings without valid business license numbers. And in late 2024, early 2025, the provincial registry will come into play, along with the removal of listings without valid provincial registration numbers. Now, we're happy to answer your questions. Just a reminder to enter your questions in the Q&A chat shown at the bottom of your screen, and please upvote the questions that are most important to you So we can be sure to cover those in the time we have.
Okay, I'll read the first question here. Will the new provincial support for compliance and enforcement be available to exempt communities that have not yet opted into the permanent residence requirement? For example, the platform accountability data sharing.
Okay, I'm going to ask Hannah, the director in our branch, to respond to that one, as she's been working most closely with the enforcement pieces.
So yes, the Compliance and Enforcement Unit will be able to support communities that are not bound by the principal residence requirement, so exempt areas. That said, the primary focus for initial enforcement will be on supporting local governments around business licensing requirements. And so the focus of the unit initially will be on those local governments with existing business licensing requirements. And the platform accountability will be focused on the business licensing requirement. Thank you. Erica.
Okay, yeah. How does the STR8, the Short-Term Rental Accommodation Act, work with Bill 44, this small-scale multi-unit housing legislation? For example, in a non-stratified property with 4 units, example, a house with a suite and 2 ADUs, where the owner lives on site, one of the secondary units can be used for STR and the other 2 rented long-term. But if the 4 units are stratified, this scenario wouldn't be possible.
Yeah, that's correct. So what happens is if you've got a property and it is a single property, single unit, and it's got a secondary suite or ADU, one of those can be rented, only one, assuming that local government bylaws allow that. But under the Provincial Act, yes, one of those can be rented. When you're dealing with stratified properties, they are individual properties, and so you wouldn't be able to treat one of those as a secondary suite if it's a separate stratified unit. Go ahead, Erica.
Hotels are exempt from the principal residence requirement, but we could not find a definition of hotel. Would it be reasonable to assume that the definition of hotel will be determined by the municipality?
So I think there's a couple considerations here. One is there's the consideration of what your rules will apply to and what ours. So in a municipality, you will have zoning rules in terms of where hotel use is allowed, and your determination and definition of hotel will apply to your rules. The provincial definition of a hotel will apply to ours. We do recognize that there's some questions around this, and so just like we provided some policy guidance in the fall, I would expect that there'll be some forthcoming policy guidance around some of these scenarios where there might be further questions and definitional questions.
Okay, next question. I am confused as to why short-term rentals are being allowed in secondary suites. These seem like a low-hanging fruit for providing long-term rentals.
So the Provincial Act, as mentioned, is setting kind of a floor across the province. And so what it allows for is it does allow for a single additional unit, whether it's a short-term rental, whether it's a secondary suite or an ADU, to be used as a short-term rental. We recognize that in many municipalities, they're choosing to ensure that those short-term rentals are providing long-term housing, and that is certainly within the authority of local governments to restrict that. We know in some cases they don't allow short-term rentals, or they don't allow short-term rentals in secondary suites for less than 30 days, for example, but that's a decision of the local government. When looking at setting the province-wide floor, the attempt was to provide a bit of a balance to ensure that we're addressing something that works in all communities while allowing communities to be more restrictive in cases where it makes sense for them.
Okay. Will Facebook, Kijiji, and Craigslist, and maybe other platforms, be required to register under the Act? Facebook in particular has become a reserve for listings.
So there's a difference between the platform requirements and the host requirements. So under the Act, host requirements, so the things like the requirement for an individual host to register, the requirement for them to meet conditions such as the principal residence requirement, All of that will apply to listings, whether they are listed on a well-known platform like Airbnb or VRBR, or whether they're listed on Facebook, Kijiji, or posted in a newspaper, put up on a bulletin board downtown, any of those sorts of things. If you are listing a property for rental for less than 90 days, you will be required to register and you will be subject to the Act. Platform requirements, however, where the platform in addition needs to register, will only apply to platforms, and the definition for that is set out in the Act, and those are ones where they are also processing the payment and the registration through the service. There's a few more details to that definition, so I encourage you to look to the actual Act on that point. But in general, yes, there is a difference between what platform requirements apply to and where host requirements are applied.
Next question here. Hotel and motels are exempt, but what about bed and breakfast? These have been very challenging to monitor and regulate as the business model is very similar to short-term rentals.
So bed and breakfast, one of the challenges here is that a bed and breakfast is a term that has been used by a number of different types of operations. And so I think the question is it a hotel or is it not? If it is a hotel, then it is exempt as a hotel. If it's a bed and breakfast, then it would be subject to the requirements of the Act. So if you've got an owner that lives on site and it's their primary residence and they're renting out rooms within it, that would generally, in most cases, be fine under the Act. If these rooms are separate suites or are additional dwelling units, then the limitations of the Act in places where the principal residence requirement applies would say that you could only rent out one additional unit, one additional ADU or short-term rental unit that is that kind of fully self-contained suite. There are some details around this in the legislation in terms of what the definition of a suite is and a separate unit. But I think in a general sense, these would fall under the Act in most cases.
Can you clarify that a local government must opt in to have the principal residence requirement apply, or is that only for local governments where the legislation wouldn't automatically apply?
So it's only where you aren't already under the principal residence requirement. So if, and the list of communities where it applies was on the website. So I'll just, if you joined late, I'll ask that maybe we share the website again in the chat so everybody's got it. There is a list of what communities are in and what communities are out, set out in the regulations attached to the Act itself. So the principal residence requirement applies in all of those communities already on May 1st. If you are not a community that is already in there, you have the ability to choose to opt in, and that's where the opt-in process applies. Similarly, if you're already in and you want to opt out, you have the ability to opt out. If you're out, you don't need to request to opt out. If you're in already, you don't need to request to opt in.
Can you explain what the process will be for confirming principal residency? Will a host be provided a confirmation that they can share with the municipality?
So there's a couple different steps here. When it comes to the compliance and enforcement unit, I would expect that they'll provide some further guidance as they get up and running. But in terms of the registration, so once the provincial registry is set up, there'll be requirements around confirming whether you are in a principal residence, if you're in an area subject to that, and details will be provided alongside the registry as to what types of data people will need to provide in order to prove that fact. At that point, you'll be able to, we will be providing the folks who are on short-term rentals through the data sharing. You'll be able to see who's got a valid provincial registry number, and you'll be able to then know that anybody who's been issued a provincial registry number has met the provincial requirements, including the principal residence requirement where it applies. But if people are asking about the types of things, well in advance of the registry being up, we'll be providing information about how people will need to prove that, and you'll be able to point them to that information.
Does the opt-in resolution by council have to be done this March 31st, 2024?
So if you would like to opt in for this year, which means that the principal residence requirement will come into effect November 1st, 2024, then you would need to have the council resolution in advance of March 31st and provide that to the province by March 31st. If it's a situation where you want to take a bit more time, there will be an opportunity by March 31st of 2025, 2026, et cetera, to opt in for future years. It's just that in all
We couldn't hear you for the end of that question. Could you?
Sure, can you hear me now?
Mhm.
Okay, great. Yes, so just around the opting in question, I'll just start again because I'm not sure where you lost me. So if you want to opt in, you need to opt in by March 31st of any year. So there'll be an opportunity by March 31st of 2024 to opt in. If you opt in by that time, if you pass the council resolution and provide it to us by that time, then you will be opted in as of November 1st of this year. If you provide the request by March 31st of 2025, you would be opted in by November 1st of 2025. In all cases, it's just an attempt to ensure that there's 6 months notice provided to hosts that the rules are going to change in their area. But certainly there will be an opportunity in future years should you wish to take a bit more time to consider whether or not to opt in.
Okay. In communities where a temporary use permit policy for STRs have been undertaken to regulate STRs, will the listing of business license numbers on all advertisements also apply to temporary use permit numbers?
I'll check with Hannah to see if she's got an answer off the top of her head on this one. This might be one we need to take away, but.
Yeah, so the current act as it's written talks about the business license requirement, and it refers to the business license requirement as a defined term in the act. I think the team can go away and look at what in practice, what provisions we might consider, recognizing that regional districts have not had business licensing to date, and temporary use permits have been used in different cases. So I think that's something the team and certainly the data sharing team could take away in terms of implementation. But just to be clear that the way the act is spelled out, it doesn't include temporary use permit requirements in the scope of the act as it's currently drafted.
Can you please go over the MTI fines again? The max is still 500 and not being reviewed.
So just to clarify, there's a difference between the MTI fines and the bylaw notice ones. So MTI fines have been increased from $1,000 as the maximum to $3,000 as the maximum. Just to note that that is increased the maximum allowable MTI fine for local governments. Local governments may need to, depending on how your bylaws are structured, you may still need to go in and actually change the fines that you're issuing. But the bylaw notice ones are the ones that are under the purview of the Ministry of the Attorney General, and those are the ones that haven't changed at this point.
Will the provincial registry be shared with assessment and taxation authorities, including BC Assessment Authority and Canada Revenue Agency?
We have provided information sharing provisions within the Act, yes, to allow for sharing with the Ministry of Finance, which is where BC Assessment is, or with the CRA, and they'll be able to use that data to ensure that for tax audit purposes and other reasons.
Okay. Got a long one here. In a situation where a condo unit or similar, i.e. single dwelling unit with no tenant, currently has STR permissions and is owned as a second residence, can the owner claim that they spend 51% of their time there and meet the principal residence requirement, allowing them to continue operating the unit as an STR when they're not present in the unit?
So the way that the Act is structured, principal residence is defined as the place where you spend the most amount of time in a year. And so an individual who is making that claim is committing to the fact that they are using that as their principal residence. I think the question is, can they claim they're doing that? The question really becomes, are they actually doing it? If they're doing that, if they're spending 51% of their time there, then it is their principal residence. If they're not spending 51% of their time there, then they're making a false claim, and there's other processes around that. But I think the question comes down to the definition of primary residence. And in this case, the principal residence is the one that you're using for the majority of your time, not the one that you say you're using for the majority of your time, but the one that you are spending the most time in a given year.
And I'll just say that enforcement decisions will be at the discretion of the director for the new compliance and enforcement unit. And so they will look at a variety of pieces of evidence in determining whether something is in fact somebody's principal residence or not, or whether it's being operated as a commercial STR and is not somebody's principal residence. So those determinations will be made on a case-by-case basis based on the evidence available to the director.
Can we work with the province to allow local governments to collect outstanding MTI and bylaw notice fines through ICBC driver's license renewals?
It's not something that's been considered at this point. Doesn't mean that we can't take that away and have further conversations, but at this point, it's not something that's been considered.
Will the STR listing data sharing be made available to regional districts that have not opted in?
So I'm going to suggest on data sharing questions that people provide those through the email address that was provided. We're happy to connect you with the team that is working on setting up the data sharing system right now. It's in development, and so I don't want to be giving an answer at this point that might not be accurate a month from now. I know that the team is working with local governments around the design of this system to make sure that it's going to meet your needs. And so if many of you will have actually already been working with the folks on this side that are working on that, if you haven't been yet, and you have particular thoughts or concerns around it, or concerns about how it might work with your individual situation, haven't had a chance to share those, please send us an email to the housing.policy@gov.bc.ca email address that's in the chat, and we're happy to connect you directly with the data sharing team to make sure those considerations are thought about as the system is designed.
And I'll just reiterate from before that the initial data sharing will focus on local governments with existing business licensing. It's going to focus on business licensing for initial phases of the rollout.
For enforcement, will we be able to serve tickets via mail? Serving tickets to out-of-province owners is very tricky.
Hannah, I'll ask you to respond to that as you've been most in the weeds on the enforcement pieces.
The process by which somebody will be served a notice for a provincial contravention will be set out in the forthcoming regulations this spring. Recognize that MTI ticketing has some constraints in terms of the ability to issue tickets out of province. So we've definitely heard that, but the details of how provincial enforcement will be served will be in the spring regulations.
In terms of regional districts, does the entire regional district opt in as a whole, or can each electoral area opt in or out individually?
Yeah, this is definitely a question we've had in regards to a few different kind of discrete areas. So yes, when it comes to a regional district, you can make decisions about specific electoral areas. You can't go kind of finer detail than that. We don't want to start drawing lines on a map around particular bays or communities or lakes or things like that. The idea, though, is that a regional district can look at the electoral areas within it and determine in which ones it would make sense to apply the principal residence requirement and in which ones it's better to remain opted out.
STRs will require valid business licenses to be on listing platforms. But what about STRs that are privately listed on their own website? How will we ensure that these are following the rules?
So I think there's a couple steps when it comes to the provincial rules coming into place. So once the provincial registry is set up at the end of the year and the compliance and enforcement unit is active, anybody who is listing a unit, whether they're listing it on one of the large platforms or whether they're listing it on Facebook or their own website or something like that, will be required to be in compliance with the Act, which means they will be required to register. If they are not registered, they will be in violation of the Provincial Act, and the Provincial Compliance and Enforcement Unit will be able to take action in those cases.
But the smaller websites will be required to enable the display of business licenses, just like larger platforms.
What is the reasoning for exempting farmlands? And is the province concerned about the potential implications of this exemption on speculation of farmlands?
So there's a couple pieces at play there. One is that the ALR, in fact, already has rules that apply to land within it. And so they've got their own set of rules around agritourism and how many units can be rented and what the size of those can be and all of those pieces. And so rather than layering a separate set of requirements over top, we've left those at the discretion of the ALC and the rules that apply to the ALR. The other consideration here, in terms of your question about are we concerned about potential speculation, is that properties like this will still be required to register on the provincial registry. And so we will also still have the ability through data to track the extent to which these are being used as STRs. Should it become a problem down the road, there's always an opportunity to make changes to address that at that time.
Will the province be issuing provincial registration numbers before checking with local governments that all local government regulations have been met? Concerned that a provincial registry number may show up on a host platform, but they may not be meeting a local government stricter STR regulations. What will the process be?
So I think that's a really important consideration as we get the registry developed. We're sort of, as we're rolling this out, there's items working in sequence. And so focus right now is on this data sharing system and the pieces that are going to be launching this spring. We are at the same time beginning work on setting up that provincial registry. And there will be further details provided about how the registry will work and considerations around, like I said, things like how you might prove that you meet certain requirements, what might be required to prove that you meet local government requirements. Any of those things will be looked at as we're setting that registry in place and in regulations that will come out alongside that. So I would expect a further third phase of regulations to come late this year alongside the launch of the registry. And at that time, we'll be able to provide some more detail and additional policy guidance to local governments around considerations for that.
Will the STR data shared by the province include dates the STRs were booked? If yes, can a municipality issue fines for those dates?
So I'm going to, again, on that one, I'm just going to suggest that you send us an email and we can connect you with the data sharing folks in terms of the question of exactly what data is going to be provided and how much detail it will have in it. I'm happy to connect you with the team working on that. But as I said, it's kind of a live piece right now as it's in development, and I don't want to answer for them.
Many people, oh, got jumped over in the queue of upvotes. They're competing. Many people own a single second residence that they use essentially as a family summer home. Can they be allowed to operate, perhaps if they don't have an STR linked to their main home? Example, a person lives in Vancouver with a condo near a lake in the Okanagan. How can we accommodate this?
So I think there's a couple considerations. First of all, the primary residence requirement only applies in larger communities. So we know lots of people have cottages or vacation homes in outlying areas. In many of those areas, the principal residence requirement does not apply, and so it wouldn't be an issue. The principal residence requirement does apply in larger communities in places where there's a concern about a very low vacancy rate and needs for housing for people who are looking for permanent housing in that community. At this point, no, if you have a second property that is in an area where the principal residence requirement applies, it wouldn't be able to be rented because the principal residence requirement would apply to that property.
Question. If a local government does not have a business license service by May 1st, what is the alternative for STR operators to provide the platforms to prove they are compliant?
So if a local government doesn't have a business license requirement, local governments, the hosts in that area wouldn't need to provide a business license number in order to prove that they're compliant with local government requirements. So I think if you're wanting to ensure compliance with local government requirements, a business licensing piece is probably a good way of doing that. Like I said, in the longer term, there will be a provincial registry that will open later this year, early 2025. But at this point, the way to kind of prove compliance with local requirements would be through a local government business licensing framework.
And I'll just jump in that the compliance and enforcement unit will be enforcing the provincial principal residence requirement starting May 1, as set out in the Act. And that would be done at the provincial level, but wouldn't be done. We're not expecting local governments to enforce or monitor compliance with the provincial requirement. That will be done by the provincial compliance unit.
There are strata properties that are not zoned for residential, nor were they ever intended to be residential. They have always been intended to be tourist resort properties. They are individually owned tourist accommodation units that are permitted to be listed individually under local government regulations. We also have historically tourist accommodation zones, areas that are intended to be principally tourist accommodation, but now allow some residential. Maybe I am missing something, but the scenarios do not appear to have been accommodated within the provincial regulation. Can we expect any regulatory changes to address this matter?
I think there's a couple pieces that are relevant here. One is that in the regulations, there are some exemptions for things like timeshare properties, for things like fractional ownership properties, or for strata hotels in some situations. I think that most of the types of properties you're talking about here probably fall under one of those categories. So for example, I'll provide a bit of detail about the strata hotels one, and then I'll encourage you, if this doesn't cover your specific situation you've got in mind, I'll encourage you to follow up with email with further details. When it comes to strata hotels, though, there's two requirements that they have to meet in order to be exempt from the principal residence requirement. The first one is that they have to operate as a hotel or motel. And the second one is that they have to have a rental management agreement with people living in that property or who own units in that property that precludes its use as principal residence. So that seems to be capturing the ones that you're talking about where it was never intended to be somebody's principal residence. So an example that might be a strata hotel that was designed where people are allowed to live for a certain number of weeks in a year, and then the remainder of the time, those units are listed, and people can go to that hotel's property, that hotel's website, and book a unit in that hotel through that rental pool. Those are the types of ones that would be exempt in most cases under the Act if they meet those requirements. Again, it's going to be a little bit specific to whether they meet some of those overlapping requirements. And so I would encourage you to look to the regulations and as they set those pieces out, to look to the policy guidance that's been provided as well alongside that to local governments. And then if there are kind of further questions about specific properties or specific details in your area, would encourage you to follow up with us at the email that was posted in the chat so we can dig into the kind of specifics of your area. I also want to recognize that we're coming up on time here. So just encourage you to use that upvote feature to make sure that you're upvoting the questions you want to get answered. And we'll try and go through a few more questions here before we run out of time today.
Okay, the province defines a dwelling unit as a self-contained living unit with its own kitchen, sleeping area, and washroom facilities. We often come across suites, which were originally master bedrooms with an ensuite, then renovated to include a bar, fridge, sink, kettle, microwave, and hot plate, but no stove. Will the province provide some definition guidance on what a kitchen is or consistency across BC?
So we've provided details around what cooking facilities are, around what a suite has to have, in that it has to have the kitchen, sleeping area, and washroom facilities. I don't believe there is a definition of kitchen that is provided in there. I know that some local governments have handled that one differently. I will say that the provincial rules will be based on what the provincial definition is. Local government rules will be based on what your internal definition is, unless you're pointing to ours. I would suggest that unless Hannah's got more to add on how these is going to be enforced, this might be the type of thing that is going to come out as the Compliance and Enforcement Unit is stood up and provides some policy guidance around these sort of edge case situations as to how they're going to be ruling in situations like this.
Will provincial enforcement be complaint driven by local governments? What about residents? Can they directly lodge a complaint with the province?
So there's kind of two phases. At first, I would say yes, there will be information that will be provided by the Compliance and Enforcement Unit, both to local governments in terms of who your contact can be, and to the public in terms of how to reach out if they have concerns about a property in terms of its violation of a provincial act. But I think the other piece here is that once the registry is set up, the goal will be to be moving from that sort of complaint-driven, responsive kind of enforcement to a much more proactive upfront enforcement. So because the registry and that registration number will be required to be validated by platforms, we shouldn't see listings happening that don't have that registration number and that don't meet the provincial requirements already. So the Compliance and Enforcement Unit will be able to respond this year to concerns that exist. And then moving forward, as I said, ideally, we'll be in a situation where we'll see a lot fewer complaints and concerns coming up because the registration process will catch those along the way and ensure that the listing isn't listed in the first place. We've got time maybe for one more question here.
This should be a, oops. It's jumping around. There are short-term rental listings for RVs. Does the Act apply to the use of RVs as short-term rentals?
No, so the definition is that it does need to be a home. There are some details around accommodation types that are provided on the website. The website, which was posted in the chat, has sort of a listing of the types of things. It doesn't cover tents or tree houses, which we've heard of, or RVs or some of those other properties that aren't really considered to be accommodations. And so encourage you to look at the website and the sort of listing of what types of things are in or out. And if you've got questions about a particular example of a yurt that is falling along the edge of that line, you can also follow up with us at the email that was posted.
Do we want another one?
Sure, let's take one more and then we'll squeeze one last question in and wrap up.
Can local zoning define more nuanced uses that would be exempt from the principal residence requirement? Example, a 2-unit guest inn with a residential caretaker unit.
So I think the consideration here is that local rules can provide more stringent rules than the provincial requirement, but the provincial requirement is a floor across the province. This actually goes back to the question that was asked earlier about why the provincial requirement might not be as strict as some communities may put in place. It's because the provincial requirement under the Act is the floor. So a local government can't exempt people from the provincial Act. They can't vary the way that the provincial Act applies, but they can say that they want to be more strict in their community. So for example, the piece that was given earlier around some communities are choosing to not allow STRs in short-term, in secondary suites or in ADUs where they want those held for long-term rent. But no, in cases where the provincial act precludes something from happening, you can't exempt a property from it at the local government level. So I know there are a number of questions still in the chat. I know that staff are doing their best to type answers where they can to ones that can be answered in the chat. We will also encourage you, if your question was asked and you didn't have an opportunity to get it answered, or if you want to follow up on the information that was provided here, please use the email address that was posted in the chat to follow up with us. I want to thank you all for participating today. We hope that this has answered many of the questions you have about the new legislation and how it's going to work in your communities. And so take care and have a great day.